The ex parte motion more or less was adjourned to Thursday. What the court said was that the defendants in this matter, that is INEC and the Attorney General of the Federation, should appear on Thursday to show why he will not grant the ex parte motion that are filed. And the ex parte motion was brought as a matter of extreme urgency because of the legal position and constitutional position of things and the timeline given by the Electoral Act for the collection of declaration of interest forms and other, which for many of the parties or all of them is actually Wednesday, that is next tomorrow. And also the primaries of the political parties will take place, particularly for the presidential election, will take place on the 30th of May 2022 and the 1st of June 2022. Because of that, this is a matter of extreme constitutional importance and urgency to ask the court to interpret certain provisions of the Constitution. And because it is urgent, were it not to be heard before the timelines have given, then the entire case would have abated by a fraction of time. It would have been a waste of time. And then a situation of a fait accompli and complete helplessness would have been fostered on the court in determining the substance of the matter. The court has been established under Section 6 of the Constitution of Nigeria to adjudicate between parties, agreed parties, whether individuals versus state, on authorities, state versus states, and state versus the federal government. That is why we have the doctrine of separation of power, bifurcation of power in sections 4, 5, and 6 of the Constitution. Section 4 is that the legislature makes the law. Section 5 is that the executive executes the law. Section 6 is that the judiciary interprets the law. And this doctrine has lived on since 1748, after it was famously propounded by Baron de Montesquieu, a great French philosopher and thinker. So that is why we are here, to ask the court to interpret certain provisions of the Constitution and the Electoral Act. You see, one thing one must tell Nigerians is that, and I've always said it, because many of them do not know, and it is for us lawyers to always educate them. There is a world of difference between morality, ethics, and the law. Students of jurisprudence very well know about this. That was why when I was pontificating on this issue of defection, my rights up and appearance on television were quite clear. In taking the brief, Emiefele has not, for example, told me the political party he belongs to. That is why, otherwise we would have joined all of them. That is why we say any political party. Any political party. Is it qualified? That is the question. The judgment of Justice Evelyn Anyadike of the Federal High Court, Umuahia, struck down Section 84, subsection 12 of the Electoral Act 2022 as amended, which had said political appointees are not eligible to vote and be voted for at congresses and conventions of the political parties. That remains the law for now, but it is set aside. We call it the lex lata, the law as it is. not the de lege ferenda, not the law as you would want it to be, which is always the moral aspect. The law as you would want it to be is the moral aspect. Go to the National Assembly and get it amended. For example, the National Assembly is currently amending the Constitution. Let them amend the Constitution, and is that there also that when a governor defects, you will also be punished by losing your seat. But until that is done, a judge who is interpreting the law is not supposed to make the law. You are not a lawmaker, you are a law interpreter. But if the court says he can, because section 1, subsection 3 of the Constitution says, if any other law is inconsistent with the Constitution, which is supreme under section 1.1, then that other law shall to the extent of the inconsistency be null and void to the extent of that inconsistency. I mean, the matter is already sub judice. There's what we call the doctrine of lis pendens. Once a matter has been subjected to a court of law, even the case of Lagos State Government versus Ozekhome, decided by the Supreme Court, it says once parties are now in a matter, none of the parties should do anything that would defeat the purpose of that suit. All parties, even without the court pronouncing maintenance of status quo or granting an injunction, once parties have subjected themselves to the authority of the court, they must never do anything. Throned, even 50 years later, because the process that brought them was wrongful. So, for example, when we meet on Thursday, I believe that things will be able to straighten out. We will be able to see the way, the path through the thick forest. The court has not taken the motion as part. He has not refused it. He has not taken or refused. He just merely said, let me adjourn it to that day and let the defendants come and show cause why I should not grant it.